Whew, a lot happened today. Another court violation order.
This is the second time in this trial where a defense witness has been in courtroom inappropriately in violation of the rule of sequestration.
One of the best cross-examinations in the trial so far.
Emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know? So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? $80,000 is a lot of money, isn't it, Miss Bailey?
Depends on who you are.
Today was more obvious with the direction that the defense was going with these witnesses. However, were they consequential? Was it really a major thing for the jury? Was it really that helpful for them?
Would you call her divorce a bitter custody battle?
I would not.
Is Donna Adelson going to testify? That is the question that we've been asking for the past couple days.
But ultimately, you must choose
This is
whether
tough.
you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
The judge at this point is done with the waiting game with the defense. He makes Donna decide today if she's going to testify. If you're not caught up with the case, we have recaps on this channel recapping each of the trial days so far. I think tomorrow might be the final with the closing arguments. Feel free to join us in the live stream. We'll be streaming this live. Stop by, say hello. Other than that, let's get it started. Well, why don't we start the day off with a little bit of courtroom drama. There's a deputy from the correctional facility that the defense wants to, I guess, testify. The defense is now being told that this person doesn't want to testify, and they were told to not contact the defense.
Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on
The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
So the answer is no, they have not been disclosed to the state.
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not as witnesses, there's not very much I can do.
Why do they want to call this person? So Zellman is saying that they're trying to get in contact with someone or maybe have them testify. This person has not been subpoenaed. This person has not been disclosed to the state. I guess like they're not on the witness list. So I wonder why Zellman wants to have this person on. Apparently they tried to reach out to them and then the person was told that they should not talk to the defense or something like that. And Zellman's like, Judge, help us out. Get this person here. There's nothing I can do. Where's your subpoena?
The defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has...
So we can speak to her and find out if she has anything admissible, okay?
Jurisdictional authority limits. For someone who is not under subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
What does Mr. Zellman expect the judge to do? Look at the judge's face. He's like, you should know this. They're going to get testimony from someone else to explain what actually went down.
May or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
I mean, that sounds reasonable to me. Zellman was saying that she was told to not talk to the defense team. It seems more reasonable that they talked about it. They're like, hey, like, you can talk to them if you want. Like, we can't hold you back. You know, it's up to you. You can talk to them if you want to voluntarily. And then she's like, well, if I don't have to, then nope.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Is our understanding that Officer Franklin is now on leave and not available to be served?
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
So is she on leave for like personal stuff, maybe on vacation? I don't know. I guess Zellman's trying to make it seem like she was told to not talk to the defense, and now she was put on leave so she can duck from the defense if the defense were to serve her with a subpoena. Now, today we're going to hear from a lot of lawyers. One of them is going to be Kristen Adamson, who was Donna Adelson's attorney during the divorce with Dan Markel, so her divorce attorney. She represented Wendy from 2012 to 2014. She's also got extensive experience in family law. She's been practicing for about 37 years. I have a lot of comments about this attorney, but starting off the bat, is this the same attorney that represented Wendy? And at some point, Dan Markel was going after the attorney and Wendy. And so the attorney decided to recuse himself because they thought they might have to be a witness, because Dan Markel was essentially accusing her of filing like frivolous claims and possibly being in on it with Wendy about hiding assets. So I could see her being up here to try to clear her name and maybe make Dan Markel look like the bad guy.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you
Really? I mean, so far the jury has already seen Dan Markel's, some of his motions and some of the filings and the back and forth, and then the Donna emails. Like, it sounded like it was pretty contentious.
characterize it?
She had a relocation
Maybe she's seen worse, but it looked a little spicy to me.
case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case, because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Oh, hey, Donna's bench is like full today. Quick check their teeth. Good veneers equals friends bought with money.
Do you have to list all assets on a financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the
You mean you don't want me to list my Beanie Baby collection?
cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you
I guess with this generation, what is it, like Labubu collection?
go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital.
So again, they're explaining all this because they're going to get into the part where Dan Markel, months into, I think like in the beginning of 2014 is when he throws the accusation that Wendy was hiding assets and he was going to go after Wendy and this attorney.
So we had a hearing on the relocation. We put on Donna Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on...
She had a job offer in Miami. This whole thing, I think, was just fabricated with Donna. So wasn't there an email or a text or... I forgot what it was, but essentially someone testified. Who testified? This was like within the first couple of days of the trial. Donna was saying that Wendy had a job offer in South Florida. This job offer was going to pay Wendy $1 million a year, and that she was going to have more time, more freedom with her children. It was at this law firm. They were going to make her partner. And I was like, damn, that sounds a little too good to be true. So what happens? Wendy ends up moving down there after Dan Markel dies, and the firm didn't end up hiring her. And then the family were pissed. So I don't know if Donna was just if the person was just talking the talk, you know, or if Donna was trying to get this person to come up and testify and lie on the stand or something like that. But there was someone from that firm that came up and testified saying like, yeah, you know, Wendy, you know, we're going to offer her a job. She's going to work in my firm and stuff like that. Oh boy, but that never came into fruition. And I forgot who testified about that. Maybe was it Jeff Lacasse?
On the lawyer from the law firm that was had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood.
Oh, and I think this is the attorney that Charlie and Donna were complaining about. Like, oh, we're paying this attorney so much more money and we're losing all this to Dan Markel. They were so angry at Dan. They were so bitter.
From your conversations with Donna, was she fixated on Wendy taking this job with a guy named Gary Cohen in Miami?
Yes, that was a common discussion point.
Okay. Did she seem like it was just something that she kind of thought would be a good idea, or something that she seemed to have a real obsession with?
It came up a lot in my discussions with her about this job with Gary, you know, where she'd be making $1 million a year and she'd be a partner, and it was something that was brought up a lot, that she'd be able to take care of her kids in a way that she couldn't up in Tallahassee. After the murder had occurred, was that I asked, you know, is Wendy going to go work for Gary now? And she told me that.
Did the job end up not working out?
As far as I know, it didn't.
Okay. And understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there. And
I don't understand how this is good for the defense in any way. It seems like when they were going through the state's emails, the defense was trying to allude that Donna didn't know that when the judge denied the relocation with prejudice, Donna didn't know that this was like a done thing, that it wasn't going to be something that they can litigate again in the future. And then remember, when Wendy testified a couple days ago, remember Wendy's shitty excuse? This is what I'm saying. If Wendy ever goes to trial, I don't know if she will, but if she ever does, remember how she was testifying saying that, oh, yeah, it was denied with prejudice. I actually forgot what with prejudice meant.
Didn't you indicate you didn't know what with prejudice meant?
I think it's not something that comes up in my daily practice, and so at the time I had forgotten that it meant that it was a final order.
Right, and it was suggested or said on cross that you didn't tell your mom it was final and she was misled and she thought there was still room for it, right?
That is.
And And so she thought that there was still a chance that they can still fight for relocation. Not only that, when the state was going through the state's emails about Donna, you know, essentially saying that like she was scheming and all that stuff, well, the defense was trying to say that Donna didn't know that there was no choice, no chance.
So what happened is after the judge says if their toenails haven't been pulled out, I'm not thinking relocation, you actually stipulated to denial with prejudice, right?
Yes.
You did not tell your parents that you stipulated to denial with prejudice, did you?
I don't remember any conversation there, really.
So not knowing that it was denied with prejudice, your mother thought you still had an opportunity to get it up through your final hearing, right?
I believe so.
And so she kept writing these ugly things and giving you all of these ugly suggestions, right?
And then I was like, I have a hard time believing that. You're telling me this attorney right here represented Wendy for almost 2 years. And after they had this major hearing, she never explained to them, hey, the relocation was denied with prejudice. That means that's all that we've got. Like, it kind of sucks. Sorry, guys. Like, we can't file for this again. That's what I had a hard time believing. Not only that, but there was also, Wendy's an attorney. Wendy went to law school. She should know what it means. And also, Donna was outside of the courtroom because she was waiting to testify. You're telling me no one told Donna what was happening? She's telling otherwise. She's saying that like, oh yeah, you know, I was there. You know, I talked to my client. Wendy was there. Wendy went to go talk to Donna and tell her what was going on. I feel like it's just unfolding for the defense right now and for Wendy Adelson as well. Her attorney is here testifying, essentially saying that it seems like Wendy's lying. What a crazy thing. I'm so this is so wild to me.
What the judge had said. In basic clients, we told, well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markell, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I
talked to Wendy about that. Wendy's parents were there, so you explain it to them. Oh gosh. And then remember, there was that when I guess like when the defense was maybe trying to say that Wendy didn't know. Well, sorry, the defense was saying that. When defense was trying to say that Donna didn't know that the relocation case was just completely done. Remember how Georgia Kappelman, or maybe it was Sarah Dugan, pulled up the emails with Donna venting to a friend a couple days after the hearing, saying that it's done, there's no appeal on this, essentially to combat against what Donna's defense, saying that Donna didn't know what was going on. And then this makes it even worse. Oh gosh. How is this helping the defense like right now?
We spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
What was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to. Nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned.
She understood. Oh, Wendy, you were lying on the stand a couple of days ago. She said, Wendy understood. But Wendy testified a couple of days ago saying that she didn't know what with prejudice was. And they thought that she still had a chance and that mom didn't know that they didn't have a chance anymore. Oh, what a mess.
Her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak.
Does this attorney know what Wendy testified to a couple days ago?
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time.
And this is to address Donna Adelson trying to bribe Dan Markell with $1 million to move to South Florida. However, the defense, somewhere during the trial, they were trying to say that it wasn't a bribery. It was a financial incentive. That's what Jackie said, by the way. But if you look at Donna's email, she says bribe.
The $1 million offer was not to bribe him in what sounds like an illegal sense. It was an incentive for him to relocate himself to Miami, correct?
Yes.
Oh.
That was my
Oh, what a great rewording of that. Okay.
understanding. Yes.
But here's the thing. Donna kept saying bribe in the emails.
Does she say the word bribe? Donna Adelson.
Yes.
Man, it's a good thing that they had that other guy testify before Wendy because he just destroys Wendy's credibility. So we're going to focus on this non-marital asset for a bit because later on, Dan Markel is going to accuse Wendy and this attorney of fraud and wanting to have them disbarred because of this non-marital asset thing, amongst other things. So here's what happened.
Did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was the, if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined.
So she explained earlier that months before, they all had a meeting discussing the Charles Schwab account and the, all the assets and stuff like that. And now after the relocation was denied, and this is like months into, maybe we're getting towards like the end of 2013 and the beginning of 2014. There was a lot of back and forth between Dan and Wendy, it seems at this point. And Dan decides to go after Wendy and Wendy's attorney. So this is where they're like leading up to right now.
Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So
how is this relevant, and how is it not hurting Donna's case and reiterating the motive? I don't know. I mean, and earlier on, she said that it wasn't a contentious divorce battle.
and that was...
I think so far, she's already proven that Wendy lied about... It's possible that maybe she really sucks as an attorney and she didn't properly explain to Wendy. And it's possible that Wendy really did forget what with prejudice meant. Do I believe it? No.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendy Adelson's portion of what she would get.
He was.
After the divorce was final, did Wendy invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did.
Oh boy, can we see the event invite for that one? I want to see what the cover page is.
Invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendy Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well, and it was just sort of a, Wendy's in a good place, come celebrate my new life.
Did she vomit at the table?
Party, yeah, in Tallahassee.
So the attorney fees, including the deposition, amounted to about $30,000, and to her, she said, it seems like a lot, but typically it's a lot more. Now, they have a marital settlement agreement between Wendy and Dan. Dan will keep the house, and he was going to pay Wendy for her part for the house. Now, the assets were going to be divided equally, so $120,000 to Wendy and $10,000 to be paid for this attorney for her attorney fees because Dan Markel made more money. Dan Markel gave Wendy $50,000, and it was, done timely. However, he decides to not pay the rest. And this attorney is like, oh man, this kind of sucks because I don't really want to push it further. But every week she was asking hey, when are we going to get our money? At some point, I think she waits about 60 or 90 days where she files a motion for enforcement, essentially telling the judge that, hey, he owes us money, me and Wendy, and we haven't gotten the rest of it. Dan Markel, for some reason, is going to hire a new attorney, and he files a pleading. In that pleading, he says, well, I shouldn't pay Wendy because she breached the settlement agreement, and she actually hidden some Charles Schwab money from me. This is the Charles Schwab money that was mentioned earlier. The witness also testifies that to her, it was obvious Dan Markel wrote the pleading himself. It was voluminous and it was very personal. And then also the response itself was inappropriate and there was no chance of Dan Markel winning this. So they wanted to take Dan Markel's deposition to essentially find out why he didn't pay more, just expanding more on it. However, Dan Markel fires back and says, well, I want to take Wendy's deposition. So the witness didn't understand why, because what value would Wendy be able to provide? However, Dan Markel probably thinks differently. He probably wants to poke at her and say, hey, why did you break the marital settlement agreement? Whatever it was that she did. And then maybe ask more about the Charles Schwab money, possibly. So this witness decides to put in a protective order for Wendy Adelson. That way she wouldn't be depositioned. Some point, though, they do have the hearing, and the judge said they were very unhappy with Dan Markel.
The judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concern?
Was that a little smile that Donna had on her face? I don't know, man. It looked like a little smile there, a little micro smile. I think she was happy to hear that the judge was reprimanding Dan Markel.
And it was a series of issues that he had now about the parenting, and it was that that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to. That he wasn't that they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come. Things like that, and that that she wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time.
Yes, let's remind the jury again.
Also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendy that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may.
But did Donna know that? Did Donna think that? I feel like Donna still took it as a blow that Dan Markel was coming after her. I think it was an ego thing, and she was like, "Fuck Dan Markel for this." I think that's the reason why Donna got so angry about everything. Just because Wendy's attorney may have been like, "Hey, like there's no chance that he's actually going to win this." I don't think Donna really cared. I think Donna took it really personally.
There have been 3, and it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Donna must have been so pissed about that. She loses the relocation. Dan Markel goes after her saying that she should have supervised visits with the grandchildren. Not only that, Dan Markel goes after this attorney to the point that she had to withdraw and they had to scramble and find another attorney. We're just reminding the jury just how angry Donna Adelson can be because of all the stuff that's happening.
Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even afterwards.
They're very nice, lovely people. Okay, we're getting a little bit of pro Donna here. Look at Donna over there checking up on the jury. I wonder what they're talking about right now. Hold on.
Her family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even afterwards. They were fine. I had no issues with them. But I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Right, because what the state has shown so far was it was Donna working the behind scenes with Wendy. I was like, hey, tell your lawyer this, do that. Here, I'll put my edits in.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor.
Yeah, but you're telling me that Wendy didn't come outside and tell Donna what happened? You're telling me that You didn't explain, this attorney didn't explain to Donna and the family what happened? Which one is this? The relocation, right? Yeah, the relocation. Come on now. I don't believe that shit. Now, cross-examination with Sarah Dugan. She is going to remind the jury again about those emails that Donna wrote to Wendy, essentially telling her to put this in your legal filings. Tell your lawyer this, do that, the text messages, the emails. Now, of course, I think this one is going to try to minimize Donna's involvement, or maybe she truly didn't know that Donna really was involved, like the emails show.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings, how about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy?
If that happened, yeah. That's a lot.
Right. And at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until you were done calling witnesses.
Correct. So that's right.
Did you explain to your client what prejudice meant? Did you explain to Donna and Harvey what it meant?
Yeah.
Okay. So that's why they were...
Because Wendy's making it seem like you didn't, Miss Attorney.
In the hallway.
That's why they're in the hallway, yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. I came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. If there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face?
No.
Okay. You talked about Dan Markell not paying what he was supposed to pay according to the settlement agreement. In Dan Markell's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons, yes.
Okay. And that included the fact that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markell held in contempt of court?
I did. It was part of my motion, was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child
Not a contentious divorce, by the way.
support hearing or an alimony support hearing, if someone doesn't pay their child support or
Maybe to her, she's like, well, this is all the stuff that happened afterwards, so it doesn't count. I don't know, man. This sounds really contentious to me. She's talking about how both sides are pointing fingers at each other. Dan was accusing her of fraud and Wendy of fraud, that her and Wendy should be disbarred. Oh, gosh. She was trying to have Dan in contempt of the court.
alimony is we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay. Okay,
Really?
Because they have it. If it's a property issue, we can't really have him held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then,
could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and then I have to do this option, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly, if he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Then, at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt. I can't remember if he actually said should be held in contempt legally the way that I was using it. I think his pleadings were much more Wendi should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
She was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. And we said
Thank you, Sarah. Come on now. The way that she's describing everything.
Would you describe this divorce as contentious?
I wouldn't
You wouldn't describe it as contentious?
fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had, and we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun, but for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious is when he did that.
Was that personal attacks on both Wendi Adelson?
I think she should have just said that it was contentious. I don't know. It seems kind of weird that she's kind of like protecting that.
And you.
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No.
Why not?
Because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides, but it's rare, and I remember all of them.
Right, but not contentious.
Sometimes I don't know with the suicides. I don't know.
That's all.
Thank you.
I wonder if the jury's looking at her sideways for the contentious thing. We have a redirect by the defense.
He testified that the divorce was not contentious, but some of his pleadings post-divorce were contentious.
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markell not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know.
You don't know what she said privately, do you?
I do not.
Isn't that like the state's question? After the hearing, she appeared to be, okay, she accepted it. But you don't know what she said behind closed doors, do you? Yeah, we do know because we saw the emails and stuff. It was bad.
Concerning Wendi Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts.
It's so funny. Donna was like drafting away. Wendi was pretending to take her inputs and give it to her attorney. It would be funny if Wendi just took it and just like, okay, I'm not going to give it to my attorney. I'm just going to let my mom think that she's like more involved in this lawyer shit than she really is. We have a mini break and Georgia is pissed. The defense has broken the court's rules again, and it's the same thing. Sequestration. What does that mean? When a witness is testifying other witnesses that are subject to sequestration can't listen to other people's testimony. There's usually exceptions to this. For example, maybe like law enforcement, the person that is on trial, Donna Adelson, or if you're an expert and you want to listen to the expert testimony that is directly like on the opposite side of you, then that's okay. This, however, it just seems to be I don't know what's going on with the defense. Generally, maybe it was just a misunderstanding.
Well,
I'd like them to stop violating the rule of sequestration now.
Hold on, let me slow it down. Hold on. What's going on? Okay, I can't really hear it. Councilwoman sounds like she's really upset, but she's walking away from the microphone. Georgia, come back! I can't hear you.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to
I like them to stop violating the rules of sequestration. That's the remedy I would like to seek. Georgia's just so annoyed with the defense right now.
the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other. Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as to lay witnesses, page 63, starting lines 11 through 14, as to lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify?
Defense, what are you doing? What is going on here? Are these? I'm genuinely asking. Are these rookie mistakes, or is this an oversight, or is this just so? Audio is like kind of meh. Georgia said she was okay with Linda Bailey, who's going to be the next witness. She was okay with Linda Bailey because she's an expert, with going over expert testimony. She didn't expect, I guess, Linda Bailey to be watching lay expert testimony, and the judge was saying that Ms. Adamson, the attorney that just testified just now, she's not an expert. The state never agreed to having Linda Bailey watch her testimony. Why the fuck was she here? And why should I let Linda Bailey testify next, defense? What's going on?
Judge,
Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Kind of quiet over there.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point in place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
Oof.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance, at that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
viewing Earhart.
Exclusion is like the most extreme remedy. I think the judge is gonna probably do something less severe. I don't know, maybe to just limit their testimony or something, or just let them testify.
Exclusion of the witness. Court may exclude witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
So now the court wants to figure out whether or not the next witness, Miss Bailey, the one that they're discussing about, whether or not she learned something new from sitting in the former Wendy's divorce attorney's testimony, the one that just happened just now. What's going to happen is they're going to have Linda Bailey go up on the stand and they're going to ask, hey, did you learn anything new? She's going to say no. And ultimately, the judge is going to allow her to testify. But before we get to her testimony, here's what the judge says.
There has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of a witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent
Donna's like, bring Dan back in here. Give me Dan Rashbaum.
the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state, she reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who was subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter.
Whew, okay, so our next witness, number 10, Linda Bailey, the marital family law expert. She's been a family law attorney since 1994, and she mainly reviewed the divorce files between Wendy and Dan Markell. She's also went through the text messages between Wendy and Dan back in 2014. some other miscellaneous texts, and also text messages between Wendy and her mom, emails between Wendy and her mom dating from 2011 to 2017. Not quite sure why it went all the way up to 2017. She's going to go over what she thought Dan Markel was requesting.
He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. What they're trained to do basically is teach people how to communicate, teach people how to be reasonable.
Now, maybe this seems a little boring to you guys, but I want you guys to listen because there is a point that the defense is trying to make.
During the underlying litigation, so between September 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery?
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so, for example, if you believe that a party has an asset that you're...
Okay, so through the other attorney, Zalman clarified saying, all right, so, you know, maybe things were contentious after things were settled. But during the divorce stuff, things were fine. And she's like, yeah. So I think they're kind of playing on a technicality here where technically the divorce proceedings were not contentious because they settled things pretty okay. However, it was things afterwards that happened that maybe you can classify as contentious. Because how this case has been described, the divorce proceedings between Wendy and Donna, was that the divorce was contentious. It's like, okay, well, it was still contentious afterwards then if you want to go by the defense's definition. And the stuff afterwards, it seems like things were really heating up between Wendy and Dan. Dan didn't want Donna around unsupervised because she was saying shit to the grandchildren. To me, I just feel like it wouldn't make a huge difference as a jury. It's like, okay, well, let's just pretend and say that the divorce was fine, and then everything afterwards, maybe we'll say there was some contention here or there. Okay. Sure.
They're not disclosing. And if you know...
Now, if the state made a gross misrepresentation that, you know, it was so bad between Wendy and Dan, things were horrible, you know, they were attacking each other, and then the defense goes over and says, like, oh, well, we're going to have this expert here and show that it wasn't contentious. And then when the expert goes over, you know, the emails between the two of them, and it was a completely amicable and things were completely fine, and the state was completely lying, then that's where it's like, wow, this is actually like, this is a big deal. But where I think the defense is angling at, I just feel like it just wouldn't be a huge deal for me as the jury. I guess they're saying that, like, when the final judgment was entered, she went through and looked through the divorce stuff between Dan and Wendy. There's no motion to compel. There was no third-party subpoenas, you know? There weren't parties that were trying to hide assets and not give up assets to other people. Yeah, that stuff happened afterwards. So not only was the relocation denied and shit was brewing afterwards, that's reason for Donna wanting to have Dan Markel. She wanted to get rid of Dan Markel. Dan Markel was winning. Dan Markel was destroying the attorney, I guess, destroying the Adelson family, and Donna wanted to win.
Needless to say, you didn't have to do any of
And I'm not blaming her in any way. She's just here to testify for the defense. She's just doing her job. But do we see a theme here? She is testifying to let the jury know that no, the divorce was not contentious. Screw the emails that you saw. Screw the text messages. Listen to this lady. Let her make an opinion for you. Now, you'll realize the defense is starting to qualify this by adding a time frame to the divorce proceedings.
You testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said. Often, sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them, or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname jibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, jibbers means someone who speaks gibberish. And if you look at Mr.
Did Wendy not tell you what jibbers meant? It was like the Jew in boots thing. Didn't we get that out from Wendy's testimony? I think a lot of us were confused what the fuck jibbers meant.
Did you ever refer to your ex-husband as the Dark Lord?
I don't remember saying that.
Voldemort.
But I certainly might have.
Did you refer to your ex-husband as Jibbers?
I did.
What is the meaning of Jibbers?
Jibbers was just a silly name that a friend helped me come up with to basically make him feel less scary. It was nonsense.
Did it reference Jew in boots?
That I don't remember.
What is it called? Jew in boots?
It wasn't a friendly name, right?
It was a silly name.
Did you ever say that you hated Dan Markel?
I don't remember saying it. But
did you ever say that you hated Dan?
Is this the origin of jibbers? Oh, gosh. Guys, we have the answer. Now we know. Oh, okay. So she's saying that the gibberish thing was just like, oh, it's just a silly thing. We're just going to... I don't know, man. The jury has already saw the email. They've already seen the emails. The emails are pretty bad. Her downplaying Donna's tone in the emails. Maybe the jury would be convinced and say they're like, oh, you know what? Actually, you're right. Actually, maybe the emails weren't that bad. Well, George is going to be here for cross.
Mr. Markel's motions and memorandums and responses he filed in this case. It was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay.
Now, again, these are the Charles Schwab accounts or account that was referenced earlier in the other attorney's testimony, where Dan Markel accused them of essentially hiding it from Dan, but then he knew about it. That drama.
June 21st hearing when relocation was denied. Did my client, in the emails you review, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where...
I'm sorry, but the jury, they can see these emails and communications and make up their own mind about it without having her going in there and then explaining it to us. I don't know. It's like we've already seen what we've seen, right?
Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace. I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you were representing...
Because of the relocation stuff was probably discussed in person. They were scheming.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. And I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, you know,
So in other words, her telling the jury the marital settlement agreement was beneficial for Wendy and that Wendy got more parenting than she actually asked for. She was able to get more, I guess, like custody for the first 3 years, and then we'll go to 50-50 afterwards when the kids were older. It's essentially saying that she got what she wanted, maybe even better. But not only that, her and her family were so greedy that they were fighting for relocation and they decided to kill Dan Markel. It's like, whew. Oh, man.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adelson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
I mean, and Dan Markel wasn't murdered until almost, 9 months later? So this is a portion that you can argue that was very contentious then. And that's why Dan Markel was murdered.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few months period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him and the boys for ice cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
I think when we talk about the divorce case between Wendy and Dan, and even in the media, I think when we say contentious divorce, we're talking about the divorce proceedings and then everything leading up to it, to Dan Markel being murdered. Not just looking at the divorce proceeding as a whole. I think we're just talking about it generally, that this whole thing was contentious. They were fighting over the boys. At some point, they wanted the relocation to happen. Relocation didn't happen. Dan Markel said that Wendy was lying about the assets and that she was, lying about other things, that Wendy should be disbarred, her attorney should be disbarred, and that Donna was saying things to the kids that were inappropriate about Dan Markel. I think when the media, everyone, all of us are talking about the contentious divorce between the two of them, we're talking about the entire scope right there. So for the defense to be like, well, actually, let's just focus on this scope right here where they were actually, you know, discussing the divorce stuff. That part is not contentious. I mean, I guess I can. It's like yes, the defense is clarifying it more for the jury, but still, you can't just look at the divorce itself and then anything after the judgment. Are we just going to ignore? Because we all know after the judgment, it was definitely very spicy between the two sides. I just don't see how this clarifier really helps the jury that much. I guess to explain that the divorce proceedings itself was not contentious. Donna was fine with Wendi because Wendi was given a very favorable marital settlement agreement and that there's no scheming behind the scenes. The family didn't want Dan Markel dead. But it's Donna's own actions that really damage her, crucially. It's the emails, the text messages. I mean, it gets worse after the bump and stuff, but it's Donna's actions that the jury's going to look at and be like, yeah, I mean, this expert may try to paint the picture that things are, you know, fine with everyone. However, when you look at Donna's own actions, it was very different. It shows a different picture. So it is a pretty long testimony. She's going to go through the timeline after the divorce settlement. So talking about October 31st to December with the emails of Dan Markel accusing Donna of essentially telling the grandchildren that he was stupid and saying other things about him and say that he wanted to take the sunshines away. When she goes through the timeline, she breaks down everything again. And quite honestly, I think a lot of us that are watching, and Georgia included, we're thinking, what is the point of all this? Because in cross-examination, Georgia really just gets right into it. Now, before we get to the cross-examination, I tell you, this is probably the best part of the trial. Let me share with you one of her last opinions about this.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. You know, it was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristen, because
well, they shouldn't have to these seasoned attorneys, but Wendi, you know, I guess she didn't know anything about family law. Donna probably felt real threatened because she didn't really understand what was going on. So these people were saying, they're like, oh, you know, Dan was writing all this stuff, but honestly, like, it really didn't have much merits, I guess. But if you're like a normal person and you're reading all the stuff that Dan is writing, then maybe you're like, holy shit, like, this looks like he's like destroying us. Like, we're losing. Like, look what's happening to Wendi. Wendi might be depoted over and over again. And that Wendi had to get rid of her attorney, or the attorney had to withdraw, and now the attorney might have to be used as a witness. So it's like, it's not like Dan wasn't doing any damage. There was some damage done by Dan. And I think a normal person like Donna, I think she was feeling all of that. So I know they're trying to downplay Dan Markel's involvement in his own, like, what's it called? His own documents, the motions that he was writing and all that stuff. But to a normal person, I think he would read it and be like, damn, this is crazy.
Because, again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendi of that. And that's what I would have expected from her.
Okay. Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. You know, if you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case.
I mean, I feel like she's downplaying the stupid comment a little bit. However, it's not the fact that grandma just made a statement, you know, like a stupid statement in passing. It's grandma using the kids and involving them in this whole thing. It's the principle of it.
Or a high conflict case. How many pages are in the court file?
there's roughly 570, and again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing. Or
Damn, look at that. Oh my goodness, look at that. Those binders. Oh gosh.
perhaps only one of those volumes got printed.
So the
This is all the divorce stuff?
clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages for Nova.
Thank you. Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I...
The judge was like, nope.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you to the jury room.
Oh, man.
The relocation issues within this case are certainly relevant. As to a separate other case, what is the argument that you're seeking to make for the record?
Your Honor, the relevance...
What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
What's relevance, Your Honor?
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
This witness can testify. Thank you. I mean, I don't know, Mr. Zellman, you brought all those case files up and it looked a little intimidating, and then you wanted to ask her questions about it. So I think people were a little bit they were a little bit worried.
In any way, make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Our jurors using the restroom.
Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials.
I can't wait for the cross-examination.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely,
So they were wordy and they were exaggerative.
At his requests of the court, there was no there there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
Cross-examination begins, and let me tell you, the fire that Georgia comes in with, I feel like she was just channeling all of our inner what the fuckness of this expert. I thought we're doing more. Okay. I don't mind it. All right. Cross-examination of witness number 10. Georgia Kappelman. Get up here, girl. Come on up. And Georgia Kappelman, she's already fired up from this morning, so can't wait to feel the passion.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side. And
Dude, she's so good at just being so fired up from the very get-go, you know? Usually sometimes, like, there's some attorneys that come up and they're like, okay, well, let's start from the very beginning. All right, so let's look at these emails. And she's like, what is the jury asked to do in this case? And why does your opinion matter?
And why would your opinion about whether it was a highly contentious custody case matter?
well, Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce.
Thank you. That's what I was saying about Donna and Wendy. That I don't think Wendy knew anything about the family court stuff, and that Donna was a normal person. This was something that she was going through personally. So to Donna, when Dan was drafting this, yeah, it probably looked like it was scathing, and Donna felt like maybe she was on the losing end. Georgia, is she watching the streams? Georgia?
With a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the...
This is not really her answering the question, but it's a good pivot, though. Hey, nice try. Nice try.
Other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had.
I know, I was going to say the same thing. Georgia's hair says it all. I feel like she was in the bathroom pulling at her hair or something. Like, Georgia, you got something going on right here. She's a queen. Who even are you and why are you here? Lawyer versus lawyer.
Something similar to what Mr. Markell would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants.
I don't know if the witness is purposely trying to be obtuse, but as a witness, as an expert witness, just answer it truthfully. Don't make it seem like you're trying to fight and hold out, okay, to defend. Just answer it neutrally, you know, maybe give some defense a little bit of flair, but like the fact that if we can understand what Georgia is saying and this expert is seemingly saying that she doesn't understand, it just seems like she's purposely just doing it just so she doesn't give Georgia a win, I guess. I guess the other explanation is maybe this witness is really, and she's intimidated by Georgia, but she's an expert. She's testified, I think, I don't know, I skipped through her credentials, I'm sorry, but I'm sure she's testified in many other cases. She's an attorney. She probably knows how to work in, you know, high pressure environments and stuff like that. Whew. Come on, Georgia's reference is pretty clear.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with
Perhaps.
that. You can't agree with it. Strike the question. You were asked.
Can the defense be like, hey, objection here? She's a little argumentative, making comments.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Ooh.
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Oh, I knew she was going to go there. I knew she was going to circle it back to that. Oh my God, Georgia, you are such a masterful person at this. Attorney, masterful attorney.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't
Exactly.
You have to ask her.
There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Jeez. Georgia's so good at this.
Jibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
Ma'am, have you never had criticism about your testimony in cross-examination? I don't know, man. I think she's just holding. I think when you come off as really defensive as a expert, I think that can come across as you not being forthcoming and truthful.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Ma'am.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously. But that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
no.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's a question that would strike.
There you go. All right, defense is awake now.
I'll rephrase it.
What is
Was
the objection again?
It's an improper comment on that witness's testimony.
And please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I can break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debate.
But Miss Adamson did say that they could hold Dan Markell. Didn't she say that they could hold Dan Markell in jail until he pays up if they knew that he had the money or something like that? Weren't you listening to her testimony? There's this whole argument of sequestration, and you're listening on the testimony. Maybe I heard wrong then, but it seems like Georgia thinks the same too.
Jail is not a possibility on that. You don't send people to jail for failure to pay money.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Ooh, that's not good because the jury saw it. You're supposed to review all this.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did.
Unless my memory is wrong and Georgia is exaggerating and I'm not remembering correctly, but I could have sworn we saw those emails where Wendy was doing exactly that.
Probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
Rewatching this cross-examination now, it's just as spicy as watching it the first time.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
Well, obviously. Jeez. She's annoyed.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
There we go. We circled back finally, and she agreed. Earlier, she was like, well, to me, it wasn't. You know, I've seen so many divorces. Like, these weren't bad at all.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th he filed the motion that accused Kristen of fraud, so she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection or calls for speculation.
Overruled. The witness has provided an opinion. State
Well,
the cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th,
Man, if I were Dan Markel's parents, I would be so proud to have Georgia Kappelman represent this case and going up against these people.
had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead.
Oh, man. I love how Georgia is aggressive, but at the same time, you know, behind that aggression is like, she seems like a really sweet person. And her tone usually comes from more like disappointment than pure anger. Disappointment, and I would say frustration. Oh man, her and Sarah Dugan are been great so far. So you know how the defense was fighting to have this witness testify? Well, I'm glad that, I'm sure Georgia feels like she's glad that the judge ended up letting this witness testify. I don't know. And maybe the defense regrets it now. Darn. We should have excluded this witness after all.
Redirect examination.
Briefly, Your Honor.
Briefly, Mr. Zellman, are you sure about that? You sure you want to spend a little bit more time with redirect?
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No,
What?
There was no new information.
We're going to start with that? Really? We're going to start with that? Come on.
Nothing further.
Will this witness be recalled at any point?
What?
Potentially, Your Honor, but she's free to go about her business.
You remain under subpoena.
That's it? Mr. Zellman does complain about the gallery's reaction, the laughing, and honestly, to me, I just heard the laughing. I don't know what else there was. So the judge is going to admonish the gallery, telling them, you know, we don't want you guys reacting. If you do, we're going to kick you out and maybe you'll be held in contempt. You had to pay some fines or something like that. Now, they have a lunch break. Whew, that is what the jury sat on for the lunch break, that spicy cross-examination. The judge tells the defense that, hey, you know, we need to know whether or not Donna's is going to testify. I'll give you a longer lunch break today, and you guys decide, let me know afterwards. They come back from the lunch break, and lots of back and forth happening here.
Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Dan Rashbaum, who is testifying that she had to waive attorney-client privilege?
Yes, I am.
Concerning that, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received.
Oh, hold on a second. Is it Donna's other attorney? Not Dan Rashbaum, but didn't she have another attorney that was assisting her with estate planning stuff?
From Ms. Descalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
Scalzo. Is that the attorney that was representing her before Dan Rashbaum got on the case then? That name sounds really familiar. Yeah, that was Dan Rashbaum. This is about someone named Attorney Scalzo. I was about to say, I was like, is Dan Rashbaum going to be up in here? That'll be interesting. Oh boy, this is very interesting.
Ms. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Okay. That attorney. All right.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter?
Right. The judge seems concerned. Are you sure you want to do this? Okay, this means that the state can cross your attorney about things related on direct and also matters of bias. Are you sure, Mrs. Adelson? Defense, are y'all sure you want to go down this road?
We're not tag teaming any arguments of any sort.
I think Zellman's handling it.
Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
What have you guys been doing during the lunch breaks? On the other breaks? What about after the court date? After the court is over? Is it hard to meet with Donna, I guess? Why are we bringing this up now?
Testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during.
And it's not like she hasn't been sitting in the trial, listening in.
But there has been time pre-trial to prepare for this moment. There's been time during trial. And specifically, we recessed court early for you to address any issues of witnesses.
Yesterday, we ended 2 hours early.
Or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not.
Judge says she ain't special.
I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors. Let them know that we will get started momentarily. Okay.
They still want more time to figure out if Donna's going to testify. And the judge was like, we need to know. I'll give you 5 minutes.
The proceedings are public. That has not stopped peanut gallery from their comments and laughter. We are respectfully requesting that the court here allow Ms. Adelson to participate at sidebar as she is entitled, and for the court to address additional issues that are weighing on Mrs. Adelson's decision.
Like what?
Please approach. We're not going to do this for very long.
Donna's there. Jackie looks pretty concerned. I'm going to fast forward it. Georgia just chilling, hands in her pocket. So while we waited for Donna Adelson to decide whether or not she wanted to testify today, we have her third attorney witness, I guess, that's going to testify. And this is going to be her former attorney before she was replaced by Dan Rashbaum and before Dan Rashbaum was replaced by her current attorneys. Now, this is just going to go back to the Vietnam thing and how the defense is planning on really downplaying it.
I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay.
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement.
Again, a lot of the focus is on issues that are adjacent to Donna Adelson's concerning evidence and actions. Yesterday, we focused a lot on the Vietnam stuff too, especially with one of the witnesses. Like Jackie went real hard on the Vietnam stuff. Oh, and also in cross-examination of the state's witness. Man, I feel like there's so much more they have to focus on, but maybe this is like the strongest and they just want to stick with it.
Enforcement, and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Let's jump over to cross-examination by Sarah Dugan.
The verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
To Wendy.
I'm not. I'm sorry. Was that a text message to me or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay.
Oof, what a nice way to remind the jury about the text message.
At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that that was a telephone call. I don't believe that that was in person. And I was on a call, and I myself also told Mrs. Adelson that that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
Out of all the other attorneys, I think her testimony was the best because it seems the most truthful and forthcoming. Very direct to the point. We still don't know if Donna Adelson is going to testify at this point. Our next witness is going to be witness number 12 for the defense, Sarah Newhouse, Tallahassee victim advocate. This was the victim advocate that was sitting next to Wendy Adelson when she found out that Dan Markel was murdered at the police station. And so the victim advocate was essentially comforting Wendy, making sure she was comfortable. Now, the reason why they want her testimony, it's because she was sitting next to Wendy when Wendy makes a call to Donna Adelson.
Wendy Adelson called her mother, Donna Adelson, towards the end of that interview.
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what, when Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Oh, I do remember you. Okay. Yeah, she was in the police interview with Wendy, and then she came in. That was after Dan Markel was shot. Okay. And then she got to, I don't know if she put Donna on speaker. I don't think she put Donna on speaker, actually. Okay, she was sitting next to Wendy, just comforting her.
Yes.
Okay. Did this upset her? To being called her mother. Do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
And do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay, sustained.
No further questions.
Redirect.
Too late for that.
Members of the jury, you are to disregard.
That's true. Wendy did say that. She handled that pretty well. Oh, Georgia, did you do that on purpose?
The last question of the prosecutor is to be struck from the record. You may step down.
At this point, the day is coming to a close, sort of, but we had 2 hours left of the trial. We are trying to figure out, is Donna Adelson, is she going to testify or what?
If there are no other witnesses for the defense, It is time for a decision to be made.
I can tell the court that co-counsel and my client are deep in conversation. I'm sorry.
I am capable of seeing that, Mr. Zellman.
Zellman just took the narration that I was doing when Donna and Drina were at the jailhouse writing notes. Thanks for the narration, Mr. Zellman.
No narration is needed.
That's my job, Mr. Zellman. Oh boy, oh boy. I guess the judge wants to know because it's kind of like, hey, we're at the end of the day. I think those are all the witnesses that they have for the defense. Are we going to end here and maybe the state will rebut and then are we going to start closing arguments, I guess? I mean, or we could just end early, Judge. End early, let her think about it. See if she wants to... Let her marinate on it. See if she wants to testify tomorrow.
At this point, I do need a decision. Mrs. Adelson, please rise.
I think the answer is going to be no. What do you guys think? I haven't looked at the Law and Crime chat yet.
Both earlier this afternoon. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces.
Can they just ask the judge for her to sleep on it? I mean, no one's asked that judge yet. Maybe they're too scared to ask the judge. Like, hey, judge, like, I'm really sorry, but like, can you just let me sleep on it, please, please, pretty, please?
Trial. Ultimately,
This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify.
She just needs to vomit at the table and just say she's sick. Pull the Lori thing, you know? Oh, Dad, I'm so sick. Oh, man.
But ultimately, you must choose
This is
whether
tough.
you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give
Zalman says, Jackie, ineffective. Let me in there. Tag me in, coach.
you exactly 5 additional minutes. From there,
right.
Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
All right, all right.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
I see in my peripheral that they're back, so.
The extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet.
Why am I so nervous?
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well.
Now, quite honestly, I was a little surprised. I thought maybe the judge would end up giving maybe Donna more leeway. Here's the thing. The judge mentioned earlier that they will have the jury for 3 weeks, meaning there's a whole nother week that they can keep the jury for. I'm a little surprised that the judge didn't give Donna, I guess, like some more time to think about it on whether or not she's going to testify. But I mean, like I said, I get what he was saying, you know, that she was there during the pretrial stuff. There was like recess that were happening. There was like the day being released early. There were the lunch breaks for her to discuss whether or not she wanted to testify. And maybe at this point, the judge was just fed up with the defense dragging their feet. I don't know. But honestly, today's Wednesday. I kept thinking today was Thursday, and maybe the judge wanted to be finished by Friday, but they still have Thursday and Friday this week. So I will say I am a little bit surprised, just a little bit. Maybe I'm just used to Judge Boreski and the leniency that he was giving Lori Vallow at times. But then again, Lori Vallow was representing herself, so maybe you wanted to make sure that you're extra careful about appellate issues.
As I previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
So I was thinking if she testified, she might do a really good job at trying to convince the jury on some points. Like I said, I feel like she's a pretty good actress. Yeah, I was thinking she was probably leaning more no. But then she's like, oh, but then like I can't have the last word. I can't tell the jury my own story, my own version, in my own words. Oh, man. I mean, it may just sound like giving them 5 minutes, but the judge is saying that, you know, you've been sitting here, you sat through the evidence, you've had pre-trial stuff to talk about the evidence, you've had the trial, you've had the breaks, after trial, the recess, you had time to think about it. We ended yesterday early.
Do you have another witness to call?
That's what we need to discuss.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense. Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is
Remember the planners? The 2014 planner with Dan Markel's license plate in it. The 2023 planner that shows Donna writing out a bunch of lists of things to sell when she was going to, you know, leave and go to Vietnam. Now, the defense, they want to include the entirety of the planner into the evidence. The state says, no, it's hearsay. Like, what's the point? The defense does bring up this, though, that there is a portion in January 2023, so in the beginning of the year, before Donna was planning on fleeing to Vietnam, It seems like she already wrote out some of the items and maybe like the price that it might go for. So I think the defense is trying to say that, hey, you know, this is to show the jury that Donna was already planning on possibly selling these items. Now, the judge says he's going to think about it and he's going to do some more research for the rule of completeness and he will let them know.
Entries, it's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
There are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell for purposes.
Who was going to lay the foundation and some of the items that you wish to admit?
Foundation's already been laid by the state. It was seized
I
by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
No one.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing under the rule of...
But couldn't he cross-examine? Or couldn't he have gotten... Oh, maybe it was supposed to be through Donna. Donna was supposed to probably testify and say that, well, yeah, I was selling things, you know, when I was about to go to Vietnam, but I was already planning on selling those things in January. I guess no one testified to that. No one laid the foundation for that. It's supposed to be you, Donna.
The rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted. Not that she was...
Hold on. These are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
None.
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country.
I thought for the rule of completeness, even recordings sometimes doesn't apply to it. Or, I guess I'm thinking of Arizona with Lori Vallow's police interviews. Remember how this?
The argument for the 20.
Remember how the state only showed portions of it that were exculpatory to Lori Vallow? Hey, the TV is probably about $2.49. Thanks, taxi. Oh, but with Lori Vallow's statements, they weren't. That's right. It wasn't like all inculpatory. A lot of it was like self-serving statements. That she said to make herself look like she wasn't the suspect, and she was trying to make Charles Vallow look really bad. What a day for the jurors.
Next witness.
All right, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
Why was he talking to Jackie? Was he pretending to confer with Jackie really quick before he said they were going to rest, or what was it for?
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening.
Ooh, I almost forgot to film the outro, y'all. Okay, so thank you so much for watching. We are going to be concluding today. Donna Adelson is not testifying, but what if she changes her mind and the judge allows it tomorrow? I don't think so, though. The defense has already said that they rest their case, so I'm expecting closing arguments tomorrow. We'll be live streaming it. Stop by, say hello, and if you guys haven't already, feel free to check out the recaps for all the trial days so far. All right, y'all. Thank you so much for watching. Don't forget to hit the like button, subscribe, feel free, and you guys can get notifications when new videos come out. We are also covering other cases as well. And other than that, guys, have a good one. I'll see ya.